I love the fact we're already getting the discussion going. Discussion equals change. Our next speaker is one of the executive assistant district attorneys in Danny, the DA's New York County. Many would say it is the district attorney's office in the city of New York because those other counties, Kings, Queens, they used to be independent cities. It really was Manhattan that was New York City, but we won't go in the history of New York. Nitin Zavor is the executive assistant. He came up through the office. He's done so much work within the trial bureau and the numbers and statistics. So what Manhattan has been able to do, and I guess we can also talk about transformative change. I'm going to go there for a second. Many of you took over really dysfunctional offices. That offices didn't have good reputations, and I see some smiles even for folks I haven't met yet, that they're probably living this dream right now. But you take over an office, it's on the wrong track, and it's easy to think, whatever change I do, it's going to be better because so far the office is not doing the right things for the right reasons. When you take an office like Manhattan and you're DA Vance, this is an office that has not only a national but an international reputation. So how do you take an office like that and create initiatives and change? And I think the answer is data. If you don't know what your numbers are, and if you're not constantly questioning, and I'm going to steal one of Satterberg's things, what's the public safety benefit of what we're doing? If there's no public safety benefit, and you start looking at your numbers and you realize you're giving a lot of people jobs, and it's keeping a lot of courts busy, but it's really not doing anything for your community, then I think that's where you need the DA leadership. And I really look, and Nitin has been involved in a lot of our different projects, but he's such a good voice of start with your data, then drive your change. And then you can also measure your change. Are you doing it right or not? And one of the other things that someone was talking about at the break is they keep trying things, but they don't work out, or it's a lot of problems. Well, that's all part of change. And I think, having heard Nitin speak before, those are the kind of things that Manhattan has gone through also. And then finally, try not to just look at it, well, Manhattan can do that. They have all the money in the world, but can I do that in my office? Many of these things, it's not because you have the money. It is doing the right things for the right reason. So at this point, I want to hand the mic over to Nitin, and let's hear about Manhattan's story.
Thank you. So I've been a prosecutor for 19 years, and when I was hired back in 1999, the starting salary for my class was $39,000 a year. Right? To live in New York City on a salary that low was tough. And my fiance, who's now my wife, she was a school teacher in New York City, and she was making like $28,000 a year. So I'd said to her at the time, hey, this is a great opportunity for me to work in the DA's office. There's a 3-year commitment. So why don't I work here for 3 years, learn as much as I can about the law, and then I'll move on to something bigger and better after that. Well, my commitment ended 16 years ago, and I'm still at the DA's office because I think that there's very few jobs out there for a law graduate than working in the DA's office, right? As rewarding as working in the DA's office. So let me fast forward now to 2009. I'm about a 10th year assistant in the office, and our boss, the legendary Robert Morgenthau, calls us all into this huge grand jury chamber to address us. 500 lawyers all in a room, and he gets up on stage, and he's 90 years old. And he says to us, my older brother emailed me the other day. Right? So he's 90. And he said, Bob, you should have retired about 30 years ago. And that was the way Robert Morgenthau told us he was not going to run for office again in 2010. Now, he was a DA for 34 years in Manhattan, right? So for us, there was a lot of anxiety in the office. Who's going to be our next DA? How is the office going to operate, right? And so we started watching the campaign, listening to who's running. And the name Cyrus Vance kept popping up. Now, Cyrus Vance had been a DA in our office for a number of years. He left, went to Seattle, worked as a defense attorney in Seattle, and then came back and was a defense attorney in Manhattan. So on the campaign trail, he's talking about things like, public safety, like most prosecutors do, but he's also saying things about reforming the criminal justice system, doing racial disparity studies to affect bias in the courtrooms. Right? And this is back in 2009, where we hadn't heard a lot of this. At least the line assistants hadn't been focusing on reforming the criminal justice system. We were focusing on just doing our job, which is prosecuting cases and trying cases. So it was really novel to hear that at the time. And so, he got elected in 2010. And when he came into office, he inherited, an office that had a reputation, but also that had problems in certain areas. So, for example, we had one of the busiest criminal courts in the country. Now, Manhattan is small. I think it's 22.7 square miles. From top to bottom, it's about 13 miles. From east to west, it's like 2 miles at the widest. Actually, it's 2.3 miles at the widest, right? But yet, for such a small geographic area, it had one of the busiest criminal courts. 100,000 cases would come in, or actually 110,000 cases would come in every year, right? 90,000 of those would be the lowest level misdemeanors and violation cases. 20,000 would be the more serious felony cases. Well, no one really had concentrated on the criminal court, right? We concentrated on felonies, we concentrated on white-collar investigations and prosecutions, but criminal court was just, people thought of it as this is a circus. There's just too many moving parts. It's an overburdened courtroom. You can't fix it because there's just too many players involved, right? But the DA said, hey, if 90% of our people are going through this court, then we should focus our resources on trying to fix this court. So this was novel for us because the mantra in our office was deal with criminal court for 2 years, and then you graduate and you become a felony assistant, and then you can really become a prosecutor in Supreme Court. That's where all the action is. So everyone overlooked this criminal court for the year or two that they were assigned to it. But now you have a DA that comes in and says, hey, let's focus on this court. Let's see what we can do about cleaning this court up. So it was a very novel approach. And what we had was, we had exorbitant caseloads at the time. Because you had 90,000 misdemeanors and violations coming in, our ADAs had 300, 400 cases. I recall having to counsel and advise as a criminal court supervisor assistants who had 425 open cases. And how do you do justice when you have 425 open cases? What I advised them was, look, make 2 stacks. Take 1 stack and put all your serious cases, your domestic violence cases, your victim cases, assaults, menacing, weapons, DWIs, and everything else that's low-level, quality of life, just put it aside, because you're not going to be able to work on everything, and hopefully this other stack will resolve itself. But we want you to concentrate on these serious cases. So we had ADAs with huge caseloads. They were assigned 5 days a week institutional assignments. They'd have to work on their cases after hours. Right? We couldn't try cases because we only had 22 judges in the courtrooms, and half of them were assigned to arraignment parts, calendar parts, and these cases would just churn. If there were no court parts, they would get adjourned for another 6 weeks for another trial, and if there were no court parts, they'd keep getting adjourned, and victims stopped showing up, cops stopped showing up, people didn't have confidence the case would ever get tried, and as a result, we had a ton of dismissals. So even though everyone talks about Manhattan being a very, like a beacon for other offices, we had problems that we didn't even realize because no one was studying the problems. No one was using data to find out what was our dismissal rate. How many cases are getting adjourned every day for trial, when both sides are ready. So that's what the DA did when he came into office right from the get-go. He said, let's focus on criminal court. Let's give these younger assistants some breathing room so they can actually work on their cases. So he employed an all-hands-on-deck approach. And it was pretty interesting. Every single lawyer in our trial division, now we had 3 different divisions, but our trial division had about 300 lawyers, going all the way up to the DA and the executive staff. He said every single lawyer in the trial division is going to take 10 cases, right, away from these misdemeanor assistants. So we took 3,000 cases out of the mix. And he said every single lawyer in the trial division is going to work 1 institutional assignment a month for 3 months. Let's try this as a pilot. And as a result of this 3-month pilot, 3,000 cases were taken out of the misdemeanor caseload. All these institutional assignments were handled by more serious people. Even the DA was down working in arraignments. And we found that by analyzing the results during that 3-month period, our dismissals went down drastically. We were able to do more trials. And so we thought that this is a good thing. But you can't have homicide prosecutors handling misdemeanor cases, right? You can do it for 3 months, but after that, it's not gonna fly with the rest of the assistants in our office. So we knew that we needed to do something different. And one of the things we did do during this time was we went to the courts, and this was our first time we were actually proactively reaching out to the courts and saying, this is our game plan. We actually want to try more cases. We're going to reduce them as bench trials. In New York City, if you're charged with a Class A misdemeanor, you get an automatic jury trial. But the prosecutor can reduce that case to a B misdemeanor and elect for a bench trial, right? So it's much easier to get a case tried as a bench trial because all you just need is one judge. You don't need to have a jury pool. You don't need to have a certain courtroom that can accommodate a jury. So we went to the courts and we said, let's get as many bench trials as we can. Can you have these judges, if a calendar part goes down in the afternoon, can we do a bench trial there? So we put this pressure on the courts to say, during this experiment, let's see how many cases we can try. And we found out that we tried such a larger number of cases during this experimental phase that it was very helpful for us with the courts at a later date. So what did the DA do? He made a bunch of changes to our executive staff. Put in pretty much a new cabinet, right? He took a part of our office that was called planning and management. A bunch of college graduates, their job was to really apply for grants. Oh, there's an identity theft grant from Washington, D.C. to pay for some work in identity theft. They would apply for these grants. But they didn't really do any kind of data capturing and analysis. And what we did was we transformed that planning and management group from grant writing to actually building for us a database so we can identify what's happening in our courtrooms, what's happening in our office. So they created for us, and it took us, 8-9 years into it. It's still being improved every day. But they started creating reports for us so we could find out what is happening in our courts. How many dismissals do we have? How many trials do we have? What are our dispositions? Because before that, we didn't really have that data. It was all anecdotal. If a supervisor asked someone, hey, why did this case get dismissed? They would say, oh, well, the cop didn't show up or the lab report never came. And there was no way to actually measure if that was happening or not. Who are the ADAs it was happening to? Which bureaus were they happening? So it was tough to rectify the problem if you didn't know what the problem was to begin with. So that's one thing we did. We created this report called DannyStat, actually giving our supervisors data on how their assistants were doing so they can hold them accountable, right? And not in a way where you embarrass them and you call them in like a CompStat where there's a lot of pressure to maintain certain stats, but it was actually as a tool to tell supervisors what's happening inside their bureaus and to tell the executive management as well, how can we fix these problems that we're just seeing happening? We also tweaked our plea guidelines because our plea guidelines, especially in criminal court, hadn't been changed for decades, and some of them were not as reasonable as they should be. So in New York, we have something called an ACD, an adjournment and contemplation and dismissal. You don't have to plead guilty to anything. If you stay out of trouble for 6 months, your case gets dismissed and sealed. We started looking at, can we offer that more, as opposed to requiring a person to plead guilty to disorderly conduct, a violation, which is not a crime. So we reworked our plea guidelines, and we found a lot more cases were being disposed of at the very first arraignment, right, because of the reasonable guidelines. We also started doing things like consenting to hearings, right? In motion practice, the defense attorney would have, like 6 weeks to file motions. A lot of times, if she didn't file motions, the judge would grant her another motion schedule, and then ultimately we would file our response. And what the judges would do is they wouldn't even look at our response. They would just grant all the hearings that the defense attorney asked for in their motion. So if there was a statement, a Huntley hearing would be granted. If there was an ID procedure, a Wade hearing. If there was any property, a MAP hearing, without even looking to see what our response was. So we said, why are we actually adding on this case age and adjourning cases for months and months? for motion practice if the judges are just going to give the hearings to the defense attorney anyway. So we encourage our ADAs to consent to all applicable hearings. If they're going to get the hearing, let's just consent right from the get-go, and we'll avoid this whole 2 or 3 month adjournment for motion practice. And the reason why we started doing that is we started paying attention to case age, because what we found was that when a case got adjourned 3 or more times, it had a 50% chance of being dismissed. So we realized it behooves us to try our cases as fast as we can. For the defense, case age is a good thing. Delay is good for them. The longer the case progresses, the more things that can go wrong with it. We have a statutory 3-month deadline for Class A misdemeanors, 60 days for Class B misdemeanors, and 30 days for violation cases. On felonies, we have 6 months of chargeable time. If we go over that time, the case gets dismissed. So for us, we wanted to speed up that clock, not delay it. And we also, and I mentioned to you earlier, we also started doing more bench trials. And we also started keeping track of what was happening when cases were on for trial. And this is something that even the courts don't do to this day. And I would strongly suggest, if you can, this doesn't take a lot of work. It requires a survey to be given to every assistant when they have a case that's scheduled for trial. And the assistant has to answer, was this case on for trial? Yes or no? Did you answer ready for trial? Meaning your witnesses were here, your cops were present, your victim was present. Yes or no? Did the defense attorney answer ready? Yes or no? And did the case get sent out for trial? No. If not, what were the reasons? Was it because there weren't any available trial parts? And most often, it was just because there were not enough trial parts. And we use this data, and you can see, like in 2015, there was 1,119 times that both sides answered ready for trial. Defendant came in to have his day in court. The victims were there, the police officer witnesses, eyewitnesses, and the court said, sorry, we don't have an available part for you. Let's adjourn the case for another 4 or 6 weeks. We took that data and we went to the Office of Court Administration. We went to the Chief Justice for the New York Court of Appeals and we said, look at this. Look how many times our cases are being adjourned. We need additional judges. We need additional court clerks. We need additional court officers. And this is why, because of this churning of cases due to court inavailability. Right? And as a result of that, we got more judges. And you can see those numbers go down. We went from 1,100 times in 2015 to almost 700 times in 2016 to 182. Now there's such a pressure on the courts, and it's self-imposed to get cases tried quicker because we showed them the data that delay was there. So you've heard a lot about conviction integrity. Just had a panel on it and how important it is. Well, the DA, 3 months into office, he said, I'm going to establish a conviction integrity program. And there's 2 main purposes. One is to reduce the incidence of wrongful conviction, and also to review prior convictions to see if there are any kind of actual innocence claims. Right? So we started doing that 3 months into the DA taking office. We have a conviction integrity committee in our office. We have a chief. We also have an outside advisory panel of experts that advises our office as to the best practices. Now, I have to be honest with you. When the DA first said to us, hey, I'm going to implement a conviction integrity unit, right from the get-go, there were a lot of line assistants that were a little defensive about it. I said, wait, why do we need a conviction integrity unit? We're fair, we're just. So there was a little, pushback until they realized how helpful this unit can be. Until they realized when they have a problem with a single identification witness case, what are the best practices? What are the checklists? What should they be asking that witness before they go to trial? When they have a cop that has some kind of disciplinary record that needs to be disclosed, when do you disclose that? What's the disclosure? So this is where conviction integrity really provided our ADAs with useful tools, best practices, protocols, and procedures on how to handle these cases, active cases, and even they started reviewing cases that already had been disposed of. And I believe they reviewed more than 200 claims of people that were convicted going back to 2010. They did 19 reinvestigations. They vacated 7 convictions, and they've overseen 39 post-arrest but pre-conviction exonerations since 2015. right? So now the office is very proud of the fact that we have a conviction integrity program. They use the unit very frequently, and they provide so much guidance to our line assistants on all types of issues. So it just goes to show that there might be a little resistance initially, but the DA said, you know what, that's okay, let there be resistance. I know I'm doing the right thing. And he's had that attitude on a lot of different things that the assistants have initially questioned, but eventually saw the wisdom in what he was doing. Second thing he did right out from the get-go is he created a crime strategies unit. And this was a very novel approach to crime reduction for us, because normally in our office, we were very reactive. A police officer makes an arrest, they bring the case to us, we prosecute that case. The officer may or may not know a lot about the defendant that he or she arrested, might not know a lot about their background. Our ADA might not know that, and it was all siloed information. So what the DA said was, look, if we want to reduce crime, not just prosecute cases, we actually want to reduce crime, we need to find out, using intelligence-driven prosecution strategies, we need to find out who's driving crime and go after those folks and find out where crime, which precincts have the most crime, and send police officers in those precincts. So that's what we did by we assigned 6 senior people in the office to work on all the precincts in Manhattan, and their jobs were to find out what the issues were in those precincts, to find out who the people that were driving crime, to bring that information back to our office in some kind of system where the line assistant who's standing up on a case knows that this person is wreaking havoc in the 2-5 precinct, therefore we should ask for higher bail than normal. So all this information became centralized. So initially, a lot of people in the office said, well, why do we need a crime strategies unit? They're not prosecuting cases. I don't need additional help on my cases. But eventually they realized how useful it was, because the crime strategies unit brought them information about the defendants they were prosecuting that they had no idea, because they were not, our line assistants are not out on the streets talking to precinct commanders, talking to, intel sergeants, finding out about who's driving crime in those areas. So that's another thing he started defining unit right from the beginning. An interesting thing he said to us when he addressed us was, look, I think the role of and you heard this from Dan, and maybe it's a Seattle thing, right? But he said that the role of the prosecutor is not just to make arrests and to prosecute cases. I mean, that's not just the role of law enforcement. It's one thing they do, but they should do more than that. To maximize public safety, we want to try to prevent people from coming into the criminal justice system in the first place. Let's get them while they're young. Let's keep them from getting arrested. Let's get little kids, for example, out of the family court system so they don't graduate to come into the criminal court system. So one of the things we started in 2011, and we've done it to today, is our Saturday Night Lights program. We found a gym that was in Harlem that was not being used on a Saturday night, and someone said, hey, why don't we open up that gym? We'll work with the NYPD and PAL. We'll open up that gym, and we'll invite all these kids who live in that area to get off the streets on a Saturday night where they could have bad influences. Let's put them in this gym. We'll pay for almost semi-professional trainers, and we'll teach them basketball. Right? We teach them other sports. So we started that out with one gym. Ultimately, now we have 12 different locations throughout Manhattan. We're about to start in other boroughs as well. We want to have one site in all the other 4 boroughs, and we've partnered with the NYPD, with PAL. We've had 12,000 youth that have come into these sites, and they learn basketball, baseball, rugby, soccer, and dance. Right? And so the goal is, let's get these kids some of them are like 11 or 12 years old. Let's give them positive role models at a young age, and hopefully something clicks and they might not get into trouble if they were just hanging out on the streets, right? So that's one example of an initiative we did that really didn't involve court-involved youth. We're trying to prevent court-involved youth. We also had to figure out what to do with those tens of thousands of low-level quality-of-life cases that would come into our court parts every year. And I told you during that pilot, that all-hands-on-deck pilot, we had senior people in the office handling turnstile jumpers and marijuana smokers. Well, that can't last, right? But we didn't want to clog up our misdemeanor assistants with these cases right after that pilot ended. So we decided, let's create a quality of life unit. We went to the court, and here's where we were actually, going to the court and saying, we want you to create a part in the court system that handles these cases. In the past, we kind of let the court create their own parts. We didn't really get involved with the court system. Here we went, the DA, myself, and other executives, we went to the head of OCA and we said, we want you to create a part called the quality of life part. We want to send all these low-level cases. We're talking about turnstile jumpers, marijuana possessors, trespassers, shoplifters, all these victimless, low-level misdemeanor cases. Let's assign them to this part. Right from arraignments, we'll send them to the part. In this part, we'll put them right on for trial. We'll consent to all hearings. We'll give you expedited discovery for the defense. We will have paralegals assigned to notifying police officers. And whoever's in that part on that day will answer ready and will try the case that same day in front of a judge. And so we didn't even use up judicial resources because we asked the court to hire retired judges. In New York, there's something called a JHO, a judicial hearing officer. They're per diem judges. They're past the age of working. So now we had JHOs staffing the part. So it didn't take away judicial resources. And we invited 2 area law school to become clinical partners with us. So we have clinic students who actually staff the part. They stand on the calendar. We assign them cases. We have clinic directors that are ADAs in our office who supervise them, and they handle these cases. Right? So it doesn't take up our resources. It doesn't take up judicial resources. And we put these low-level cases into this part where they're all handled by the same JHO. So there's consistency, there's fairness, and all these cases that were in the past getting dismissed by the boatloads, now they're getting prosecuted in a very timely fashion. I have to be honest, the defense bar absolutely hates this part. Right? Because now you have these eager beaver third-year law students who are like, oh, I'm answering ready for trial on the shoplift case. Whereas, in the past, that case just died on the vine when no one paid any attention to it after 3 months. Right? So if you look at the stats, we've had 25,000 cases put into this part. And only about 1% of them actually go to trial. The rest of them all get disposed of. But this is why our speedy trial numbers, our dismissals, really drastically decreased, because these were all the cases that no one really cared about and were getting dismissed left and right. So the DA, and I mentioned this earlier, when he was campaigning, he talked about racial disparities and he wanted to study that. Well, the Vera Institute actually approached us and said, you had mentioned that you were interested in racial disparity studies. We're willing to do one. You don't even have to pay for it. We got a grant from the National Institute of Justice to do a study. So could we use your office? And he said, absolutely. Right? So this was a study where an outside organization was going to come in. We were going to open up our books. They were going to look to see what was going on in our office. Right? And then they were going to write a report about it. And they were going to publish this report on their website. And they're going to do a press conference about this. So people in our office said, no, don't do that. Why would you want to open up our books to some outside organization and air all this stuff out? Right? We're not racist. We're not biased. We're we're fair. We're just, right? You don't want to do this. And he said, absolutely, I'm going to do this, because if my goal is to try to improve the criminal justice system, if it's to try to remove problems, to try to make it more fair and equitable, how can I do that without knowing where the problems are? So we had them come in. They moved into our offices. They were there for 2 years. We gave them 200,000 cases over a 2-year period for them to study. We asked them to look at our case acceptance. We asked them to look at our dismissals. We asked them to look at our pretrial detention, our plea offers, our sentencing offers, and tell us, are there disparities? Are blacks being treated differently than whites? Are Latinos being treated differently than whites? Are Asians being treated differently than whites in our office? And in what areas? And guess what? They found disparities existed, right? For most of us, look, we took these jobs because we think that we want to protect victims, and we think that we're fair and we're very reasonable, but there are implicit biases in all of us, right? And so disparities come out. And that's what that study showed, that there were disparities. But for us, it was so perfect because it gave us a blueprint, It gave us a blueprint of what we needed to do to address these problems, right? So we started bringing in implicit bias trainers. It was mandatory for every attorney in our office, so they understood that these biases exist in all of us. We the DA appointed a chief diversity officer to make sure that all of our ADAs were trained in cultural sensitivities and bias training. We started changing our bail policies to make them, to reduce the disparities in pretrial detention. We started standardizing our plea guidelines to reduce the disparities in plea offers and sentences. So this was very helpful, even though it showed that there were disparities in our system. It was helpful for us because it kind of told us what we needed to do to address them. And for the next 5 years after that, we've been trying to slowly but surely working at addressing those issues. So one thing we did was, and this was with the help of the courts, we were one of the only 2 states in the United States that was still prosecuting 16 and 17-year-old kids as adults in adult court, right? So if you were a 16-year-old kid and you jumped a turnstile or you shoplifted, you were handled in adult criminal court. And we didn't want to be one of the only 2 states. I think North Carolina happened to be the other state at the time. But we were very upset about the fact that we couldn't convince the legislature to raise the age of criminal responsibility to age 18. So what we did ourselves, with the courts, the defense bar, the judges, we created our own adolescent diversion part in 2012. And the goal was, look, if the state's not going to do this, New York City is going to do this, right? Because we want to treat these younger kids like they're in family court, a rehabilitative model, not a punitive model. So we would have them get assessed. We would make sure they didn't get criminal convictions. We would almost ACD practically all the cases that came in, or we allowed them to earn ACDs if they went through youth counseling. We got rid of the traditional sanctions like community service or jail or fines, and we had them get counseled. We had them go to youth courts. We had them do restorative justice projects, right? But that was the goal, is that if we can't get them into family court, we're going to try to create a family court in our criminal court system. And we found that it was very favorable and useful for the kids, because most of them wound up not getting any kind of criminal conviction out of this. Another thing we did was, because we knew that there were disparities in pretrial detention, when the mayor's office approached us and said, hey, would you be interested in piloting a supervised release program for nonviolent felonies? We said, absolutely. Now keep in mind, at the time, our judges had very few options at a bail hearing, right? They can either release someone, they can set bail, or they can remand. Right? So what do you do with someone before you that has a criminal history, maybe not super significant, but they have a couple of bench warrants? Those people were getting some nominal bail set because the judges didn't have any other options. So when the supervised release pilot started in 2013 in our office, we said, bring it to us. We would love to be part of this program, because it gave the judges an additional option. Instead of setting bail on that case, the judge could now say, I'm going to release you to this third-party organization. Normally, I'd set bail on your case because of your bench warrant history, but I'm going to release you to this third-party organization, and they're going to be responsible for making sure that you show up on the next court date. And guess what? If you don't comply with them, then I'll set bail in the future. But for now, you get released right out of arraignments. So this was a pilot. We thought it was good, right? We actually felt that it should not just be for felonies, it should be for misdemeanors as well, because we had a lot of people on low cash bail in our criminal court that were being held at Rikers that couldn't make $500, $1,000 bail. But the pilot that was paid for by the city was nonviolent felonies, excluding domestic violence cases, and let's try it out for 3 years. Now, the DA, we had this youth court in criminal court, but the DA said to us, we're still failing these kids. And I said, well, Judge, I said, DA Vance, we have this part. We're actually preventing them from having criminal records. We're giving them ACDs. We're getting them youth counseling. He said, you know what, Nitin? He said, these kids should not even be in our court in the first place, and try to figure out a way that we can avoid them even coming in, even though they have to be arrested. And that's when I started looking at the Seattle LEAD program. I started talking to other counties, other jurisdictions and states to try to find out what could we do in New York City that is similar to a diversion program when an arrest is made and we don't want to have that person prosecuted in criminal court. And that's where we came up. It was our office, it was the Brooklyn DA's office, NYPD. We all met, and a provider, we all met to talk about this pre-arraignment diversion program, and it's called Project Reset. And we started in 2015. And we said, let's start it out with just kids, 16 and 17-year-old kids. And here's how it works. You get arrested by a police officer. because you committed some crime. It's usually shoplifting. The police officer says to the kid, hey, look, I had to arrest you because you shoplifted, but I'm going to give you a desk appearance ticket. I'm not going to bring you directly to the courts for arraignments. I'm going to give you a desk appearance ticket that's adjourned for 9 weeks. And there's a program that the DA's office is sponsoring. And I'm going to recommend you for this program. And if you do this program, it's 2 sessions of youth counseling. Then they're not going to prosecute you. The case will be dismissed. You will not have to show up in court. So off the bat, this fosters a positive relationship between the police officer and the youth that got arrested. Then we had the defense attorneys involved. They would contact the kid and say, hey, there's this program. Did you hear about it? We're going to represent you if you show up in court 9 weeks from now. But we're telling you, do this program so your case gets dismissed and sealed. So the kid would show up to the program, and there'd be 2 counseling sessions, right? It could be individual counseling, group counseling. It could be a youth court. It could be a restorative justice art project. At the very end of that second session, we get notified that the kid complied, and we would decline to prosecute the case, and the case would be dismissed and sealed. We started that with 1 precinct. The following year, we had in every precinct in Manhattan for our 16 and 17-year-old kids. And so far, we've had over 1,016 kids are currently enrolled in this program. We've had 970 that have already completed it. We have a 98% completion rate. We were really impressed. We thought that young kids, will they show up for the second visit? Maybe they'll show up for the first one and not the second. There's been a 98% completion rate with that. And we like it because it keeps the kids out of the courtroom. It fosters a positive relationship with the police. You know, it saves us time because we're not prosecuting these cases, we're not drafting these cases, we're not arraigning these cases, only to tell that kid, hey, we're going to dismiss your case in 6 months if you do a day of community service. So there's many reasons why we thought this was a really good model, this pre-arraignment diversion when you're given a desk appearance ticket, and we've replicated it in many other types of crimes and age groups in our office. But you can see, you know, almost half of the young adults were females, half of them were males, half of them practically were 16, the other half were 17. The number 1 charge was shoplifting, the number 2 charge was marijuana, the number 3 charge was trespassing. But these are low-level crimes. They don't involve victims. I mean, we don't consider shoplifting a victim crime, although there is a corporate victim there. So because we like this, and because we thought it was working, and because we looked at recidivism rates and it wasn't harming these kids, if anything, it was helping them out as far as whether they're getting rearrested at a rate similar to people who weren't in the program before it started, we said, let's expand this to adults. So in February of this year, we said, okay, if you're 18 or above, if you're 88 years old and you shoplift and you don't have a criminal record, we're going to put you in this pre-arraignment diversion program. That's one thing I forgot to mention. It's for people who didn't have criminal records, right? Low-level first arrestees, or they had prior ACDs, or they had prior sealed cases. That was fine. But this was not meant for someone who had a criminal conviction. So with the adults, we said you do 1 session, right? Forget about 2 sessions, 1 session, and it could be counseling, it could be naloxone training, it could be drug counseling, it can be community service, and we're going to decline to prosecute your case. And so we've had already, since this year, we've had about 692 people in the program. There's 172 that are currently enrolled in it. 500 have completed it already, and we have a 96% completion rate. So we're starting to reduce the number of cases that are coming in by diverting them, which is something we hadn't done in the past. We also started looking at people who have C summonses. In New York, you can be arrested or you can be issued a criminal summons by a police officer. Usually that's for a violation or a non-penal law offense. Predominantly like opening containers of alcohol, public urination, lying on a subway bench, or taking up 2 seats on a subway, or walking between subway cars. But believe it or not, there's hundreds of thousands of these cases, these summonses that are issued every year. And if you looked at bench warrants, there was about 1.5 million people in New York City, you know, had these warrants because they didn't show up to court. So we started saying, how can we help people clear up their warrants? Because if we can help them clear up their warrants, the next time they're stopped by a cop, the cop doesn't have to arrest them. Because if you have an open warrant, the cop is forced to bring you to court in front of a judge to vacate that warrant. So we started something called a clean slate program, which is that we would create a courtroom inside of a church, a community center. We'd invite people from the community, all 5 boroughs, to come in, and you would clean up your warrants. They would stand online, they'd come in, they would meet with the defense attorney would have access to their summons history, and if they had a warrant, we would clear it up. We'd vacate it, dismiss it, either ACD it, or we'd dismiss it outright. And so people started realizing that, hey, we're not getting arrested if we show up to these events. People realize that we can get our summonses cleaned up. We're no longer fugitives. They were more cooperative with police officers in the future. They were more cooperative with our office because they weren't scared. They didn't have as many consequences because of they were a fugitive of justice. So we've done one a year for the last 4 years. We've had about 1,740 people come in off the streets to clear up their warrants. And we also paired up with the resource fair. We have community providers outside, food, different kinds of benefits. You can sign up for different services. So we make this a nice event, and we're about to do another one very soon in a homeless shelter. So we're going to try to attract all the people that are living in shelters like Ward's Island, thousands of people that have warrants to help them clear it up. So the Vera report told us one thing. They said, you're taking in too many cases. You have 110,000 cases, 90,000 misdemeanors. You're basically prosecuting everything that the police officers bring in your door. And should you be doing that? And we asked, why should we be prosecuting every single case? Let's pick and choose what we should prosecute. Like, if our goal is public safety, what's the public safety value in prosecuting someone who had an open container of alcohol or who walked in between a subway car? So we decided to stop prosecuting certain cases. We met with the NYPD. We told them, hey, look, and we started this in March of 2016. We said, we no longer want to prosecute violation cases, these infractions, low-level cases. They're not even misdemeanors. But you'd be shocked to hear that we would get 10,000, 12,000 of these cases every single year in our office, right? So we'd prosecute, we'd write up, we'd arraign, we'd dispose. They all got time served because they were so low-level cases. So we said to them, look, we don't want to prosecute these cases. We want to work with you so you can give them criminal court summonses. If they have warrants, we'll work with you to return them on the warrants, but don't rearrest them and put them through the system where they spend 24 hours in jail on a new charge. Give them another C summons on the old charge and the new charge, and we'll bring them in and we'll clear them both up. But we did not want to handle these cases anymore. And as a result, we went from having 12,000 cases of these violations, and those numbers started going down. And as you can see, our violation numbers went down 90% if you look at 2009 compared to last year. So we're at a high of 12,461 in 2011. In 2017, we had 1,500 of these cases. We still told the NYPD, okay, we'll prosecute some of them. There are some violation cases that are actually serious, and they do impact public safety. Driving while impaired is one. There's some illegal knives possessions. There's possession of K2. So there are some penal law violations like harassment that we're still going to prosecute. But the vast majority of them were like low-level, open containers of alcohol or public urination. And as you can see, that helped us reduce our intake by about 10,000 cases. So you make one policy change in your office, you can have a huge result in the intake. We also said, hey, we want to increase supervised release, not just for the felonies, we also want to increase it for misdemeanors. And the city said, well, sorry, there's no money for that. All we can afford right now is for felonies. Well, we happen to be fortunate because DA Vance prosecuted a couple of international banks, and we did have some asset forfeiture money come into our office. And that money did amount to roughly $808 million, right? So we had $808 million of money that we couldn't use on ourselves, right? We couldn't give ourselves raises. I mean, I wouldn't be wearing a cheap suit if I had $808 million in my pocket, but we could use that on different criminal justice initiatives, right? So we said, hey, let's pay for supervised release for misdemeanors. It was our idea. And we'll not only pay for it for Manhattan, we'll pay for it for every single county. So we gave $14 million to bring supervised release into New York City for misdemeanors as well. Right? So we want to try to reduce the number of people that are being held in on low-level bail. Whether you're a misdemeanant or you're a nonviolent felon, jail should be reserved for only those people that need to be there. So we started this supervised release program in March of 2016. It excluded violent felony cases. It excluded domestic violence cases. And so far, we've had 2,125 defendants who normally would have been incarcerated out on supervised release. And the majority of them, 1,470 of them, were for felonies, for nonviolent felonies. 655 were for misdemeanors. And you can see what kind of cases we're talking about. The felonies were grand larceny, drugs, forgery, burglary, and the misdemeanors were drugs, assault, and petty larceny. So this is a good thing for us. We also started thinking about, do we need different specialized courts, in addition to quality of life? Should we bring more specialized parts into our criminal justice system? And we work with the Office of Court Administration, and we created a young adult part, ages 18 to 20-year-olds, right? Because we know that adolescent brain development is not that much different for an 18-year-old than it is for a 17-year-old. So why should it be that only 16 and 17-year-olds get these specialized services and the 18, 19, and 20-year-olds don't? So we expanded our part to go up to those that are 20 years old. We also created a human trafficking intervention part because in the past, we actually prosecuted prostitutes like they were just regular defendants. Now we started to realize that many of these people that we're prosecuting were actually victims of human trafficking. So we look at them differently. So now we have this human trafficking part where we bring them in, we try to get them out of this profession, we try to build cases against their traffickers, and we basically dismiss their cases if they go for counseling services. We created a drug part in criminal court, and in Supreme Court, we created a veterans court, a mental health court, a judicial diversion court for drugs, and a youth part for Supreme Court. Right? So these are basically parts where you're charged with a felony, you do a program, and you wind up getting your case dismissed, or you get a misdemeanor as a result of doing the program. So I talked to you about these clean slate programs, right? We'd have these 4 programs in a church or in a community center, and one of them, 700 people came in on a very cold day in November, right? But so we started thinking, what about the 1.5 million people that don't come in? Maybe they live out of state. Maybe they live in elsewhere. Can we somehow en masse vacate their warrants? So we started a dialogue in the city with the NYPD, with the other DA's offices. Do we all feel comfortable just en masse vacating and dismissing these 1.5 million cases? Now, it took me 2 years to try to convince everyone to be on the same page, but ultimately what we wound up doing is the PD was they felt that they didn't want to dismiss warrants that were just new. They wanted to at least wait for people that are 10 years or older have stayed out of trouble. So we said, okay, there's about 750,000 people who have 10-year-old warrants. Let's dismiss them. And then we carved out a couple of public safety exceptions. So in one day, and that was in August of last year, 4 out of the 5 DAs all showed up on the same day in different court parts throughout New York City, and we dismissed en masse all these warrants. And so in Manhattan, we had 240,000 warrants. So the DA stood up and he said, on counter number 1 through 240,001, I'm moving to dismiss them in the interest of justice. So they cleared up all these warrants that were preventing people from cooperating, that were putting people in jeopardy of collateral consequences, that making people scared of talking to police officers. So that was a good thing, and it didn't cost any money. It was just having conversations with the key stakeholders and the courts. Of course, it took them like months and months to actually get the warrants cleared from their own computer systems because there were so many. But in one day, I think it was all told, there was something around 600,000 warrants were done, throughout New York City. So we also created an ATI unit in our office, an alternative incarceration unit, because mostly our ADAs, they would care about a case, but once there was a disposition and the case was disposed of, even if there was some kind of program attached, they rarely followed up with the programming, right, to see how the person was doing. Were they complying? Were they not complying? Or if a defense attorney called them up and said, hey, we want to recommend this program for our client, our ADAs had no expertise on was that a good program? Was it a bad program? Is it going to help or not? So ultimately, we created a unit. We have a unit chief and a bunch of designated assistants, and their jobs are to become experts in all the different programs that are out there. That way, they can advise each of our ADAs. If any time someone reaches out to you to talk about a program, we could actually have the final say, well, that's not a good program. This is a much better one. We recommend this one instead. So it gave this expertise to the line assistants so they can reach out as a resource. We also asked the ATI unit to handle cases that are disposed of so they could follow up to make sure people were complying. The DA also realized ever since Padilla versus Kentucky was decided in 2010, we had a lot of people that had collateral consequences. They couldn't take pleas on certain cases. Even low-level cases like marijuana possession, people were getting deported for that. And so a lot of defense attorneys will reach out to us and say, look, my client can't plead on this charge because of the consequences, or my client has employment consequences if they plead on this charge. And our line assistants were not knowledgeable on this, right? So the DA appointed a person to be our counsel for collateral consequences. Her task was to become, an expert in all the different issues and advise our ADAs as a resource. When we talk about that asset forfeiture money, the DA put $250 million of that aside just for community justice initiatives, right? So one of them was creating youth opportunity hubs. Put aside $45.9, almost $46 million to create 5 hubs in different parts of Manhattan for young kids to come in off the streets, at-risk kids. They don't have to be court involved. They can come into one of these 5 centers. There's 80 different service providers all linked into these 5 different centers. They can get counseling. They can get educational help. They can get tutoring. They can get drug counseling. They can get mental health help. They can, a whole host of resources. It's a single-stop facility where they can come in and all their needs can be addressed. So that's something we've done. We've had 2,500 kids show up to these centers so far, right? The DA also took $12 million out of the asset forfeiture money and gave it to different existing programs in New York City that were dealing with at-risk kids. So with the goal that the kids will not become part of our criminal justice system. Vera had criticized our pretrial detention rates, that they had disparate impact on blacks and Hispanics. And so we decided, we didn't really give our ADAs a lot of guidance on bail policies. We tell them, okay, look at the rap sheet. Look to see if there's a bench warrant history. Look to see if there's any kind of criminal history, and then ask for appropriate bail. But earlier this year, on January 9th of this year, we actually implemented an official bail policy for misdemeanors, and I actually drafted it myself. And a few months later, we implemented one for felony as well. So now we're giving our ADAs guidance, and the guidance is, on a misdemeanor case, the presumption should be there's no bail. Don't ask for bail on a misdemeanor case. Ask for an ATI. Ask for supervised release. But really, and if you're asking for less than 30 days jail, you should not be asking for bail. There are some exceptions, and we gave them a list of exceptions. If you have a victim case, or you have a police officer that was injured seriously, or if you have, someone with an extensive criminal history or an extensive bench warrant history, then bail may be appropriate. But the standard should be, don't ask for bail. We're trying to flip the narrative, because in the past, the narrative was always ask for bail on every case, right? Even if it's small amounts, right? So on the felonies, same thing. If you're not asking for more than 6 months jail, you should consent to release on felonies as well. So as a result, we just started this earlier this year, but as a result, our bailout requests in criminal court weren't that high to begin with. They're almost like 19, 20%. They've gone down to about 16% since this policy has been come into effect. And one of the things we're trying to do in the future is we're going to look at this and figure out whether we can even improve it more. We stopped prosecuting many different cases, right, that we thought that there was no public safety value in doing so, and we had just been doing so because of the fact that the cops brought them to us. So on February 1st of this year, we stopped prosecuting fare beaters, theft of service cases, someone who jumps a turnstile or goes under a turnstile or goes around the turnstile. Believe it or not, we get 10,000 of these cases every year. We said to the NYPD, please don't arrest them and bring them to us. Give them a criminal court summons instead. I mean, obviously there are some small group that for public safety reasons we might want to prosecute, but that should amount to 10% or at most 15% of the population. But for the other 85%, please give them tickets instead. So we've reduced our intake by a huge amount just because of that one charge, which was always historically the number one charge in criminal court was theft of services, right, for transit fare beaters. We also said people that were selling, food without a license or selling merchandise on the streets, these unlicensed general vendors, there were only about 800 of those cases, but we said we don't want to prosecute those people either. We don't think there's a public safety value. We next went to marijuana possession, and that was on August 1st of this year. We said we get 5,000 people a year that are smoking weed, and we find that those people are predominantly people of color, and they're all being arrested in communities of color, right? Yet we think that marijuana is a problem that is an issue that everyone is partaking in, right? So we did a 6-month study. We showed the study to the NYPD. We showed them all the data. We showed them that this cohort of marijuana possessors, they're not violent. They don't have violent criminal histories. They just mostly have marijuana and other low-level stuff. And so as of August 1st of this year, we stopped prosecuting these cases as well. We also went in September and we dismissed 3,042 existing marijuana cases that were open with bench warrants that were dating back to 1978. These are people that had a marijuana case. They never showed up. There was a bench warrant. We dismissed them en masse. I think Dan had mentioned this. We have unlicensed drivers, people who didn't pay their tickets and their license got suspended. We divert them as well. We have a Project Greenlight. You pay off your tickets before your arraignment date, we dismiss the case. Or if you're arraigned, you pay off your tickets after the first date, we dismiss your tickets. The only exceptions we make is when your license has been suspended for something serious, like a DWI case or a drug conviction, or if you fail to pay child support. Then we actually prosecute you. But for the most part, we've had almost 484 cases dismissed pre-arraignment since this program started in April. We created expedited discovery policies for our office, and we provide them to the defense bar. In New York State, you can hold out before turning over discovery until the eve of trial, or actually, before the witness testifies. But our assistants traditionally were turning over the discovery material when the trial started. Right? We said, look, let's turn over discovery during motion practice. Right? There's some exceptions, but on non-victim cases, turn it over early. Don't turn it over, on the eve of trial. At a bare minimum, even if there's no motion practice, turn it over at least 2 weeks early. So that's something, it's a change that we're doing. We've always been concerned with victim intimidation and witness tampering, but we're trying to push towards getting the information to the defense bar as soon as possible so they can make better decisions with their clients. We also did an expedited discovery for felonies as well, right? And I know I only have about 5 minutes left, so I'm going to make this quick, right? Drug addiction, opioid addiction, right? It's a crisis in New York City, like it is in many of your jurisdictions. So we have more people that are dying from these overdoses because of fentanyl than car accidents, or heart attacks. So we decided most of our pre-arraignment diversion programs were for people with low-level criminal histories or no criminal histories. We said, we don't care what your criminal history is. If you're possessing drugs, right, we would rather dismiss your case and get you treatment than prosecute you. So for people who get desk appearance tickets, they get arrested, they get brought to the precinct, the cop tells them, are you ready to do this program? Because if so, I'll call a peer navigator right now. And the peer navigators that we've hired work on a 24-hour, 7-day-a-week basis, and they tell us, we'll get to the precinct within 1 hour from the time the call comes in. So even if it's 4 a.m, a navigator will show up to the precinct, and they'll take this person to the center. And if they do 2 sessions, right, usually there's an intake, and then there's one meaningful engagement after that, we'll decline to prosecute your case. And we don't care what your criminal history is, because for us, it makes more sense to keep you alive than to have one more conviction on your rap sheet when you might already have 100 convictions in the past. So we do this program for pre-arraignment diversion for those who receive desk appearance tickets. For those that are arrested because they were not eligible for desk appearance ticket, we're doing post-arraignment diversion. It's called our OR program, Overdose Avoidance and Recovery. You basically, at arraignments, you say, I need help, right? You're screened for some kind of opioid addiction. If you're willing to go for help, we don't even ask you to plead guilty. We'll just dismiss the case at the very end, right? Raise the age finally went into effect October 1st of this year. Right? So in Supreme Court, we have this youth part, all the nonviolent felonies now go to this part, they get special services, and we've consented to a supervised release pilot in the young adult part that allows violent felonies as well. For these young adults, we're okay with getting them released out of jail even if they committed robberies in the second degree or assaults in the second degree. And the reason for that is because for this pilot, there's services attached to the supervised release. It's not just getting someone to show up in court, it's actually addressing some of their issues. And just to go over our overall Rikers population, there's been a push to try to reduce mass incarceration, to reduce any unnecessary incarceration. Well, in New York City, we would get 12,000 people at Rikers on any given day in 2015. This year, we get about 8,000. So we're reducing the people that are going in there. And if you can look at our stats, but there's reasons. If you look at the Manhattan population, there's reasons why those people are being detained, because they have extensive criminal histories and they have extensive bench warrant histories. Just so for the last 8 years, all the things that we've talked about, and I didn't talk about everything, but all these things have had a profound effect on the way we do business in the DA's office. It has a profound effect on the way we interact with the defense bar and how we interact with the courts and on our actual metrics. So as you can see, our dismissals in the past 8 years have gone down 42%. Our speedy trial dismissals have gone down 32%. Our trials that we started went up 75%. Our bench trials went up almost 200%. And our DWI cases, which we take very seriously, have gone down 52%, and our speedy trial dismissal 64%. So if you look at our misdemeanors that have come in, we've actually reduced our caseload by 50% from when we first started. I gave you a snapshot of what the criminal court was like before DA Vance started, and we had 93,600 cases in 2009. Well, this year we're going to end up with something around 43. I ran the numbers at the end of October, and we were at 38,000 cases. So it's a huge reduction, right? And it's all those people are not being arrested. They're not being prosecuted. So what I'm going to tell you is this, is that although we've done a lot, we continue to figure out what more can we do to reduce the number of people that are in jail. Jail should only be, there shouldn't be a set number, but it should be only for people who belong there. So we continuously look at our reports, look at data to evaluate the person that had bail set on them yesterday. Should bail have been set? I mean, I get these reports every day, and all these initiatives I talked about, we have data that shows us reports of what happened the day before, so we can make sure that our ADAs are following our policies and make sure that we're doing the right thing. But what we're going to look to do next, a couple of things that are on our agenda, is we need statewide bail reform. We have an antiquated bail statute that doesn't even allow our judges to consider the risk of danger of the defendant or the dangerousness in the community or public safety. So that's one thing we want to look at. Another thing we want to do, and we're currently in the works, is expungement. If you have a conviction in New York State, that stays forever. You can't get it expunged unless you have a governor's pardon or there's a vacatur due to some kind of defect in the proceedings. So we're looking to draft some kind of expungement statute. We're also looking to seal marijuana convictions. We have really pretty good standard guidelines in criminal court for misdemeanors. We're working on felony guidelines to reduce disparities in our office just between the different bureaus. And we're also looking for transparency to put some of our select measures, our data, on our website so people from the public can see what we're doing and hold us accountable. So thank you.